Welcome in the session 2 of the Trade Union Act 1926. Earlier in the first session, I had a discussion with you regarding the trade union, rights, liabilities, where is the registered office, why there is a need to get it registered, what are the formalities to get the trade union registered. After all these things, now the need is in this session to proceed further. Here the objective is to cover up that what are the criminal conspiracies in the trade disputes, how to get settled the trade disputes, what is basic requirement of trade disputes, and the conclusion would be the clear understanding of these consequences through this act. Now, the criminal conspiracy in the trade act, in the trade dispute. Now, in this where not the office bearer or the member of a registered trade union shall be liable to punishment under the act. In respect of any agreement made between the members for the purpose any such object of the trade union unless the agreement to commit an offence. This is basically the criminal conspiracy in the trade dispute, where the section of 18 of this act provide the immunity from the civil suit, where no suit or other legal proceeding shall be maintained in any civil court against any registered trade union or any office bearer in respect of any act done in contemplation or furtherance of the trade dispute, to which member of the trade union is the party on grounds only that such act induces some other person to break a contract of the employment. Another one is the enforceability of agreement. In case of the enforceability of the agreement, that is under the section 19, where an agreement between the employer of the trade registered union shall not be void or voidable merely by the reason that any object of the agreement is in restraint of the trade. So it is provided that nothing in the section enables any civil court to entertain any legal proceeding to express purpose of reinforcing or recovering. What recovering? The damages for the breach of any agreement for the condition of the Trade Union Act. Now, what are the rights? See, the rights to inspect of the trade union, though are under section 20, where the account books of the registered trade union and the list of the members open to inspect by the office bearer or the member of the trade union, they can inspect any time. Section 21 says the right of the minor to the membership of trade union is there, where any person who is having the age of 15 more may be the member of this union, of this trade union, and as per the rule of the Trade Union Act 1926, so he has the right to execute all the instruments and give all the acquaintances necessary to execute as per this rule. Now, if I talk about the disqualifications, do we have any disqualifications? Yes. What are those? Let me discuss with you those. The disqualifications of the office bearers of the trade union as per the section 21A. Though are with a person disqualified when not attained the age of 18 years, when convicted by the court in India, when is under the offence of the moral turpitude, right? And in case the member of the executive or office bearers of the registered trade union before the commencement of the Trade Union Act convicted of any offence involve the moral turpitude. Okay? So these are the few disqualifications. Now, the change in the name. Can we change the name? Can we change the name of our union? Yes, we can change the name of the union. Section 23 says any registered trade union with the consent of not less than 2/3 majority of the total members, quorum, which is said as quorum, as per the section 25, change its name. Now, what is the notice of the change? The notice of the change of the name is under the section 25, that notice in writing of every change of the name, amalgamation, if there is any amalgamation, with the 7 members of the trade union, signature, change in the name of the trade union is possible, right? It should be informed to the registrar of any state. So the proposed name should be identical with that which can be the other existing trade union registered with the opinion of that registrar. That name should be possible, and as well as the registrar be satisfied that the provision of the act in respect of the change of the name should be compiled with, and along with that, in case if there is any amalgamation with the effect from the date of the registration, the name will be changed, right? Now, dissolution of the trade union. Now, if anyone asks that is it possible to dissolve the dissolution of the trade union, is yes, section 21 of the Trade Union Act 1926 says very clearly that dissolution of the trade union is possible when the registered trade union dissolve the notice for the dissolution signed by 7 members at least by the secretary of the trade union within the 14 days of the dissolution be sent to the registrar, shall be registered by him if he is satisfied the dissolution be effected in accordance with the rules of the trade union, right? Then where the dissolution of the registered trade union registered and the rules of the trade union not provided for the distribution of the funds, the registrar shall divide the fund among the members and dissolve it, right? So in this way the trade union dissolves. So I hope it is clear. Let's recap. What is that dissolution? How the criminal conspiracy in the trade union is there? What is the act? And the act 24, 25, 26, 27 we did. Let me explain you now about the Industrial Dispute Act. Industrial Dispute Act. So in this session I am going to discuss Industrial Dispute Act 1947. And what is this 1947 Industrial Dispute Act, and how this act is affecting the disputes, controlling the disputes, what is the scope of the act, what are the objects of the act. I will explain you in detail. Please like and subscribe my sessions so that I can contribute more towards the quality of education. Thank you. In the next session, we will discuss about the Industrial Dispute Act 1947.